This is Odessa. She is 17 years old, recently been diagnosed as a type 2 insulin-dependent diabetic, and has just experienced a hypoglycemic episode whilst driving. These are the two paramedics, Ezra and Prakash, who attended the scene of Odessa's car accident and treated her. Odessa is refusing transport to hospital, so it is up to Ezra and Prakash to determine, firstly, if there's any immediate risk to Odessa, secondly, to consider her mental state, thirdly, to recognise the relevance of her age when making medical decisions, and lastly, to determine if placing Odessa under an emergency examination authority is the most appropriate course of action in this situation. Firstly, Odessa's mental state and her rights in relation to the capacity of her mental well-being must be considered. Within the Mental Health Act, Queensland 2016, Section 3, Subsection 10, a mental illness is defined as a clinically significant disturbance of thought, mood, perception, or memory. Before making decisions in regards to how they will deal with Odessa, the attending paramedics must ensure they can justify depriving Odessa of her liberty. Ezra and Prakash must form the reasonable belief that the following criteria is met. 1. The person's behaviour indicates the person is at immediate risk of serious harm, and 2. The risk appears to be the result of a major disturbance in the person's mental capacity, whether caused by illness, disability, injury, intoxication, or another reason. And 3. The person appears to require urgent examination or treatment and care for the disturbance. In relation to this case, it must also be considered whether Odessa has a mental illness or whether she did not have the capacity at the time to make sound decisions. According to the Powers of Attorney Act 1998, capacity may be defined as ensuring the individual is capable of understanding the nature, assessment, treatment, and consequences of their condition. In relation to Odessa, a minor under 18 years of age must prove to be GILIC competent, ensuring they hold capacity to make informed healthcare decisions. In determining capacity, age, maturity, education, nature of the medical condition, associated risks, and consequences of refusal must be considered. In acting with capacity, the individual is enabled with the opportunity to make decisions for their own healthcare, whether that be in the consent or refusal of receiving assessment and treatment. Distinguishing between capacity and a mental illness may prove difficult, with the Public Health Act 2005 allowing emergency examination authorities to treat individuals lacking mental capacity due to illness, disability, or intoxication, among others. However, previous or current mental illness does not always determine the capacity of a patient. Capacity may be classified as a transient state whereby a patient must exhibit a complete understanding of all aspects of their condition to be considered GILIC competent. A patient must illustrate sound and reasonable judgment of their decision to prove capacity. As it is a transient state, patients may understand their diagnosis, however they may not fully comprehend the gravity of the situation, including the consequences of refusing treatment. This is extremely relevant in relation to Odessa, as she is making dangerous decisions that demonstrate she is not fully aware of the extent of her condition and the consequences that may follow. Following the examination of Odessa, she is found to have no injuries, although paramedics worry that she may have another hypoglycemic episode. Hypoglycemia can present, according to the Queensland Ambulance Service Clinical Practice Manual, with anxiety, and although the paramedics cannot initially find issues with Odessa, transport and an emergency examination authority, also known as an EEA, is required. This is because it cannot be fully determined in the field whether she is having disturbance in thought, mood, perception, and memory. QAS outlines that if a person is at immediate risk of serious harm, authorization is allowed. In this situation, as Odessa has had a hypoglycemic episode and her thought, mood, perception, and memory cannot be accurately tested in the field, it puts her at immediate risk of serious harm to herself and the public if she continues driving. Although she is unlikely to have a disturbance of thought, mood, and memory, it is highly plausible she is exhibiting difficulties in perception. Odessa's age is an important aspect of this case, as it can firstly affect the rights she has had and secondly change the level of responsibility placed on the paramedics. According to the Child Protection Act 1999, Section 8, A child is defined as an individual under the age of 18. In this case, as Odessa is currently 17, she is still seen as a child according to the law. In regards to consent for medical treatment, according to Legal Aid Queensland 2017, the patient must be capable of making their own decision or what is proposed. Legal Aid Queensland 2017 also states that they must show that they understand the nature, consequences and risk of the treatment. The treating clinician must consider the patient's maturity and intelligence, whether or not they understand what the recommended medical treatment is, why the medical treatment is needed, what the medical treatment involves, and also any risks related to it, such as potential complications and side effects. After considering all aspects of Odessa's mental state, capacity and age, it must be determined whether she proved a valid refusal of consent. Odessa has only recently been diagnosed with diabetes, therefore, despite being aware of her condition, she may not fully understand it or the associated risks involved. It is apparent from Odessa's blurry vision and that she lost focus while driving that her diabetes has the potential to cause at least a small degree of cognitive impairment. Capacity is assessed in the context of how much risk is involved with the decision. In circumstances where there is higher risk, a patient must not have a greater understanding of the decision they are making. Overall, Odessa did not have capacity to make sound decisions in regards to her medical state, as she was not GILIC competent, therefore making her valid refusal of consent void. With consideration to her mental state, along with her capacity, it can be concluded that Odessa was unable to make appropriate decisions and the paramedics were right in applying an EEA to prevent further harm to Odessa and the general public.